Have you ever heard these supervillain sounding legal terms, but you don't know what they meant? They sound really cool and you kind of want to use the term, but again, you don't really know what it means. Well, for me as a student, when I was in law school, one of those terms was the Mareva Injunction, or the Mareva. There's Anton Pillar orders as well, but this video specifically will focus on what a Mareva Injunction is and what it looks like in real life. If you're new to the channel, hi, my name is Pam Matani. I'm the principal lawyer and founder here at Graphene Business Law, a law firm providing virtual legal services throughout Ontario to business owners and entrepreneurs, whether it's launching your business, growing your business, or concluding your business through any number of requisite procedures. If you're new to this channel, go ahead and give this video a thumbs up, and of course, don't forget to subscribe. Here on the channel, we regularly post content that's relevant to business owners and entrepreneurs and law students as well. This video is kind of, I think, ear-catching and eye-catching to both because it focuses more on a concrete legal term and test and process that I think has appeal on both sides. In law school, we hear about Mareva injunctions, and it's this, like, you know, you hear the terms white knights and pills and this and that. You hear these super cool terms here and there, touch and go. And in practice, we know that some of these terms, some of the clients coming our way, they're having to deal with them, but they don't really know what they mean either. So I wanted to put this video out there and talk about one of these terms one at a time. In the case of this video, the Mareva Injunction. Okay, what is it? Big picture, any injunction, by the way, although there's positive injunctions that can have you ordered to do something, big picture, most often injunctions are negative in the sense that you stop doing something. That's what an injunction means in legal terms. If there's an order for an injunction, it means there's an order for you to stop doing something most of the time. When it comes to a Mareva, well, this is a kind of injunction that is seen as being super harsh in law. It's a really, really harsh, tough remedy, okay? It's difficult to obtain by the party trying to put an injunction on whatever, you know, in this case, I was going to say whatever you're doing, but in the case of the Mareva, on your financial big picture. And part of why it's such a draconian remedy is that Mareva injunctions, when they're brought to court, they can be brought without the notice of the person whose assets we're seeking to lock up, okay? And I'll go through here a little bit on the history of how Marevas came to be important in Canada and Graphene business laws in Ontario specifically. So we'll talk about, these are Ontario cases, and where the current test sort of lies, and also what can you do if you've been met with a Mareva injunction, okay? The case that made Mareva injunctions relevant in Canada is called Chattel and Rothbard, okay? You can pronounce it however you like. I'm not a stickler on pronunciation. Chattel. I remember once I had a teacher in high school who told me I gave a perfect presentation except for mispronouncing a word. I mean, I think in a country as diverse as Canada, we have better things to do than focus on pronunciation. If you're a stickler, I guess you can fast forward parts of this video, and if you're a normal human being, I don't care how you pronounce these case names. Chattel and Rothbard, that's how we'll say it here, was the first case to endorse the Mareva in Canada, okay? And 3 years later, Chattel was an Ontario case. 3 years later, we had the Supreme Court of Canada endorsing the Mareva in, obviously, Canada, okay? Going back to Chattel, though, it's interesting, in being the first case, it cites back to, what some of us at the time might have seen as the legal motherland of Canada, which of course is the UK. And Chattel cites a pretty well-known judge in the UK named Lord Denning, who had presented guidelines to dealing with the Mareva, okay? And I'm gonna read the guidelines, so you're gonna see me looking down because it's a literal legal test. So in order to obtain the Mareva, Lord Denning had said in the UK, and this was then imported in Ontario through Chattel, that the plaintiff should make full and frank disclosure of all matters in their knowledge which are material for the judge to know. The plaintiff, of course, being the party that's asking for this order, that's asking to lock up someone's assets. 2, the plaintiff should give particulars for their claim against the defendant, stating the ground of their claim and the amount, and fairly stating points it's making out against the defendant. Okay. 3, the plaintiff should give grounds for believing that the defendant has assets in the jurisdiction in question. So again, in Ontario, that jurisdiction is our province, the province of Ontario. 4, the plaintiff should give grounds for believing that there is a risk of assets being removed from this jurisdiction before the judgment or award is satisfied. And 5, the plaintiff must give an undertaking as to damages. Okay, there are some elements of this test that are standard, that are common when we're asking for an injunction, when we're asking that somebody stop doing something, when somebody goes to court as the plaintiff and asks that you stop doing something, or if you're the plaintiff yourself, obviously just substitute the terms. And the first, second, and fifth part of this test are standard when we're talking about injunctions. When we're talking about Mareva Injunction specifically, the parts of this test that are unique are the third and fourth aspect. And again, to remind you of that, the third aspect, the plaintiff should give grounds for believing that the defendants have assets in the province in question. And the fourth asset, or the jurisdiction in question, in our case, Ontario. And the fourth point, the plaintiff should give grounds for believing that there is a risk of these assets being dissipated. Dissipated, fancy word of saying, you know, dissolving, disappearing. So in other ways, we're presenting this case, bringing this motion without the other party even knowing sometimes. And we're saying, you know, they have the money here, they're doing something wrong, the money's going to disappear, we need to lock them in, okay? That's the big picture of Mareva. The lock-in, by the way, if you review any number of cases, you'll notice the pattern. Usually we're talking about a 10-day period. We're not locking money forever. That would be insane. And we're not locking it for like 3 hours either, because what's the point of that? We're usually talking about 10-day periods, and that can be extended or it can be discontinued depending on what goes on in those 10 days and the evidence that both parties bring forward the next time they're in court, okay? The current test for the Mareva Injunction is not necessarily different from the one we saw in Chattel. You can look to a myriad of Ontario cases for the current test. There's Sibley and Associates. There's also Electronics, Inc. and Swellum. And these cases, what they do, if you're a law student parsing through this, or if you're a business owner or a member of the public going through these cases, and it seems at first like they're different cases or different tests, they're actually not. It's just that some cases today still preserve the test as being that 5-parter from Chattel, keeping in mind that some of those factors are not Mareva Injunction specific. They are elements that you would see on any application for an injunction. And some tests, like Electronics and Swellum, at paragraph 67, a well-known judge, his last name is Perel, he goes on to provide that the test is one where the plaintiff has a strong case they're bringing forward, the defendant has assets in the jurisdiction in question, and that there's serious risk that the defendant will remove the property or disappear, you know, with these assets before a judgment is brought to court. Okay, so you'll notice that in this Electronics, Inc. and Swellum case, that looks like only 3 factors, or maybe even only 2. But then the paragraph goes on to explain how this is in addition to the regular injunction factors, right? So that's what I mean. Some cases you look at today are going to just big picture, copy and paste 5 components. And some cases are going to show 2 or 3 at a time, and then somewhere else in the case say, and the other injunction components apply. But here we list the Mareva unique components, okay? It is possible, I mean, with everything in law, it's a dance of justice, let's call it. So just because somebody asks for something doesn't mean they get it. Just because somebody gets something doesn't mean it gets to last, right? So if somebody has brought, if you're a plaintiff bringing forward a Mareva to lock someone else's assets up, it's important to note that they have a say too, and this order can be undone. That injunction can be lifted. We can look at factors in lifting the injunction, for example, at whether you made frank and accurate disclosure to begin with, or, you know, if there is actually any real risk of this plaintiff dissipating assets, or, you know, you made genuine disclosure, but you yourself had misunderstood the facts, and the facts that we now know don't support whoever you're alleging to be a flight risk to actually be a flight risk. So there's things we can do to lift the injunction big picture, and there's things we can do that if, you know, the court decides that this injunction is worth holding, that, you know, there is actually some risk here under the Mareva guidelines, you can still withdraw money for what's called living expenses and legal expenses. This obviously is, you know, we've talked about some pretty important cases on this channel, especially from pop culture perspective, and the word policy keeps coming up. There was, for example, a Pepsi Where's My Jet case we discussed here. The Netflix had done a special on it, how the case had been decided, you know, in Pepsi's favor for being this super big company. And I've mentioned how there's policy reasons going on there. Sometimes when these case results don't make a lot of sense, the big P word comes into play, and that word again being policy, public interest, things like that. When it comes to the Mareva, of course, it is a huge point of public interest and public policy that the person whose assets are locked still has, you know, human rights preserved, including being able to withdraw money as necessary for living expenses such as food and accommodation. And also, super importantly, I mean, the only reason you're having their assets locked up in the first place is because you were able to successfully navigate the legal system. Well, they have that same opportunity afforded to them, and they are able to ask for funds to be thawed out, if you will, after they've been frozen from the Mareva order. They're able to ask for those funds to be thawed out to themselves hire a lawyer to protect their interest, okay? There's a test for that as well. It is a 4-part test. We're looking at has the defendant, so the person whose assets have been locked up, has the defendant established that there are no other assets available to pay for these expenses? If the answer is yes, has the defendant established that there's assets caught by the injunction that are from a source other than from the plaintiff themselves? Point 3, the defendant is entitled to use assets not belonging to the plaintiff to pay for reasonable living expenses and legal costs, and these assets must be exhausted before we're looking at the plaintiff's assets. And, the 4th part, if the defendant has met the above 3 tests, the tests we just discussed, and still requires funding for legitimate living expenses and legal fees, the court must balance the competing interests of the defendant in ensuring that they have that proper opportunity, first of all, to survive, if we're talking about living expenses, but also to represent themselves, to present their best case in court through having counsel, if we're talking about legal expenses. So that dance of justice goes both ways. Whatever is locked up can be unlocked under the right circumstances, and it can also be locked for good if the party that brought the matter forward, if the plaintiff, either had committed any sort of wrongs themselves, if you will, including not bringing forward proper disclosure, or if it's just a number of other fact-specific scenarios, including you not really being a flight risk at all, like you were alleged to be. Okay, so there's that dance of justice. I'll keep this video there. I don't want to overwhelm with these educational videos, but the Mareva, however you say it, is one of those, it always catches our ear as if there's junior practitioners watching this, if there's law students watching this, or if there's business owners watching this that are curious or may have heard this term somewhere and you're wondering what really is it. Well, I hope this video was helpful in explaining what it is. It is a super remedy, if you will. It's a harsh remedy. We don't hand these out to anybody that asks for them. I'll leave it at that. So thank you for watching. If you have any questions or are looking for ways to launch your business or successfully grow your business in Ontario, our website is graphenebusinesslaw.ca. If you are looking to email us, the firm's sort of welcome email account is info@graphenebusinesslaw.ca. Thank you for watching.